Thank you so much for that. Unfortunately, we are running short of time. So if you have more questions,
गाना बंद करियो We are live, ma'am.
All right, thank you so much. Thank you everyone for joining in and good morning. Thank you for sparing time on a weekend to join us for this session. Prof. Marika needs no introduction now again, except the fact that I will like to add that she is now officially part of the JGLS cohort and she's teaching an elective now with us as a guest faculty at the Jindal Global Law School also. So to add to multiple things that she's been up to, we are very privileged that she is now teaching with us at the Jindal Global Law School. This lecture is something that Prof. Marika is working on for a really long time. And it will build on a paper that she wrote for something that I was a part of about 4.5 years back. So please, Professor, take it away. Thank you so much.
Thank you. Thank you. Good morning to all who are listening today. I know that many of my friends and colleagues from the United States and Latin America, including Brazil, wanted to participate in this webinar, but it's in the middle of the night over there. So when you will join, it will be when you will be watching the YouTube. Even in the YouTube, I believe it's possible to add questions in the comments, and I can look at that later to answer any questions you may have, or you can just contact me because that's how the world works today. And for those courageous ones who are tuning in on a Saturday, bravo to you. I had posted this event on social media, and as many of you know, I am Dutch. And leave it to my Dutch friends to immediately ask, what on a Saturday? So I come from the country that focuses on work-life balance, which really means that we eat our dinners at 6 and on the weekend, we absolutely do not work. So I'm a very unusual creature over there in the Netherlands. So here it is. Very exciting week. This was. I am indeed part of your Jindal family. It's really marvelous how things work, where years ago, now 10 years ago, I came to Delhi for an additional dialogue. I don't even remember how it happened that I wrote an article in the India Journal of Arbitration. The topic I picked was one that I had been privy to since 2008, which is the replacement of the New York Convention. And I remember I was in Washington, sitting at home thinking, what else is there to say? What else is there to say about the hypothetical exercise of replacing the New York Convention? And this is where, in my foggy brain, I came up with this concept of perhaps having a dual convention. When I tried to work that out, it turned out to be incredibly complicated. Nonetheless, I tried to put it on paper, terrified of the reactions. And it was none other than Fali Nariman who then sent me an email. Incidentally, with him, I had written the India resolutions for the application of the New York Convention in India. And he said, this is by far one of the most interesting pieces of academic writing that I've read in a long time, and you need to change it into a memorandum that needs to be distributed in India, which I have not yet done, but maybe with Jindal now we can. The issue now is that I wrote that article in 2016 with our students, Preeta Suresh, and it's time again to update it. So hopefully today we'll collect some food for thought and I can go back to my desk and write another article on this. So before I do so, I have to do what everybody does, and that is to applaud the New York Convention. As you know, skilled diplomats will always start with a compliment and then followed by the however, and if it follows, that is when the criticism follows. So here it goes, and forgive me for at times being cynical. The New York Convention perhaps could lay claim to be the most effective instance of international legislation in the entire history of commercial law. And this was written in 1989 by Lord Mustill in Arbitration, a History and Background. And so in my preface, in the book that I also wrote in 2016, which is in desperate need of an update, I then wrote the following. If Lord Mustill was right in considering this treaty to be of such singular importance, it must also be said that the New York Convention, as it emerged in 1958, was in many ways a strange one. Treaties are typically undertakings between states, which one state may invoke to secure compliance by the others. Treaties thus become fundamental sources of public international law. The New York Convention, on the other hand, is an instrument whose transformative effect is usually felt in the domain of private law. And this is exactly where the shoe pinches. In international law, most treaties are indeed concluded by states. They operate in the state-to-state space. They operate in the realm of international law. And it's states who will invoke those treaties, and it's states who will hold other states accountable. But the New York Convention is a treaty that is applied by judges of national courts, judges who are not specialized in international law, most of them, judges who have to adjudicate all sorts of disputes that arise in their country for which they have jurisdiction. And it's not really invoked by states, it's invoked by people. It's invoked by business parties. It's invoked by those who conclude contracts. It is the subject of litigation, domestic court litigation. The case law that follows and flows out of the New York Convention is not international judgments by international tribunals like the International Court of Justice. They're judgments of national judges. And so I have to recognize that what the drafters did in 1958 is an incredible accomplishment. And I have to recognize that over the last 60 years, it has been a very, very successful treaty in the space of international trade. And the same was recognized by Kofi Annan. And every time I talk about the New York Convention, and forgive me for repeating myself again, for those who have participated in other conferences where I talk about the New York Convention, and obviously my students, I quote the Secretary General of the United Nations, Kofi Annan, because although it's a United Nations treaty, it really is monitored by UNCITRAL, the trade branch, and it's not often the subject at the General Assembly. It is not often given attention, if you will, by a Secretary General of the United Nations or heads of states. At this occasion, it was the celebration of the 40th anniversary of the New York Convention, for which a conference was held at the United Nations with mostly international arbitration speakers, but it was opened by the Secretary General. And so this has not happened since. And Kofi Annan said, "This landmark instrument has many virtues. It has nourished respect for binding commitments, whether they have been entered into by private parties or governments. It has inspired confidence in the rule of law, and it has helped ensure fair treatment when disputes arise over contractual rights and obligations. International trade thrives on the rule of law. Without it, parties are often reluctant to enter into cross-border commercial transactions or make international investments." I cannot repeat this statement often enough, especially today. And this is why a revision of the articles that I've written and that others have written is crucial, because I must segue into what is happening at UNCITRAL today. When Kofi Annan speaks about international investments, and when he says that these international investments, these business contracts, these cross-border business engagements, they thrive on the rule of law. And one of the most important treaties to enable the flourishing of international trade was and is the New York Convention. But it's also the ICSID Convention, to which incidentally India is not a party. It's also the thousands of bilateral investment treaties. It's the regional conventions. It is the presence of ICSID. It's the presence of the Permanent Court of Arbitration. Investors are confident investing around the globe in regions such as Latin America, in Europe, in Asia, in the MENA region, because they have protection under international law. Investors would be less confident in what one call the local rule of law and engaging in negotiations with a local government, with a national government, let's say in a country in Latin America, when they are left with the local courts as the only resort. Investors are confident to invest across the globe because they get investor state protection. Now, this protection can be given under bilateral investment treaties, but as Kofi Annan points out, there are also other contracts that are concluded that give protection. How do they give that protection? Alternative dispute resolution, international arbitration. Why is that so crucial that we need to understand that it was the Secretary General of the United Nations who emphasized this? It's because it's now that other branch of the United Nations, UNCITRAL, that has undertaken an effort to replace this system with a world court, a court that has adjudicators that are appointed by sovereigns, a court that does away with party autonomy, a court that does away with the traditional understandings of international arbitration, a court that does away with the international rule of law as we know it. And this will impact international investments, and it will impact the role that the New York Convention plays. So I want to park that, even though it's not relevant for the actual replacement of the New York Convention. Now, the success, 60 years, I'm going into the numbers because sometimes math matters, but I'll prove at the end of this lecture that it didn't, because numbers are just numbers and age is also just a number. The convention is over 60 years old. Apparently that's a good thing because it's still alive. The convention applies, I checked it yesterday, 168 contracting states, and more than thousands of decisions have been reported to the International Council of Commercial Arbitration. And it is the publications committee under the leadership of Silvia Borelli that then makes sure that those decisions are summarized, translated, and offered in the ICA yearbook. Most of these decisions showcase that judges tend to grant enforcement. So whenever I discuss this replacement of the New York Convention, the immediate rebuttal is why it is so successful, because of the numbers. It was so successful that a small group of international arbitration specialists has proposed to present ICA, Pete Saunders, and the yearbook and the New York Convention in a way to the Nobel Prize Committee to see if Pete Saunders, may he rest in peace, and ICA could win a Nobel Prize for the success of the New York Convention.
Prof, there's a hand up. Do you want to take questions in the middle, or do we wait till the
I would
end?
be happy to take a question.
Yeah, Professor Marisport, you can ask your question.
Ma'am, actually, sorry for raising this question very beginning, because I have this issue with regard to New York Convention's applications, even sports arbitration award and even investment arbitration award also, they are invoking the New York Convention. Does the original text of New York Convention kept that into account of these kind of issues? Even the German court also discussing about human rights issues, which is there in the sports arbitration, right? So does the New York Convention actually taken into account of sports and the investment perspective at the time of dealing with that? Because this issue actually pondering me longer time, how it actually come into picture. It would be grateful if you please could clarify.
Thank you so much. So what I think how I understand the question correctly is when you look at investor state arbitration and you look at sports arbitration decisions, so the CAS, the Court of Arbitration for Sports, in 1958, did the drafters thought of those decisions and would they fall under the New York Convention, correct? Now that's fantastic question. And sadly, since my book could only be like 250 pages, I had to cut parts of my book, but I do think I actually kept the part of CAS, because this relates to Article 1.2, permanent arbitration bodies, and 1.1, the scope of the New York Convention. So what actually happened is, as many of you may know, that if you, well, I would never participate in the Olympics, but if one were to participate in the Olympics, you have to sign a bunch of agreements. And one of them is that you agree to submitting any dispute to the Court for Arbitration for Sports, to CAS. And so a dispute emerged. I think it was Olympic, I think she did cycling, well, something like that. And so what ultimately happened is that this athlete, objected to the jurisdiction of CAS. And so the question was it really voluntary? Was it really based on party autonomy? Is CAS a permanent arbitration body that falls under Article 1.2? And is CAS an institute that adjudicates dispute through international arbitration that's based on party autonomy, that's based on a party agreement, and that's based on parties voluntarily submitting their disputes to CAS? Because these athletes have to sign that agreement, otherwise they can't compete. So the question was, is it voluntary? The same question arose with the Iran-US Claims Tribunal. Now, when it came to CAS, that decision was put forth with the UK courts, and they were very practical about it. They said the Olympics travel around the globe, and it's a good thing that the adjudication mechanism is in Switzerland and will always be in Switzerland and will always be there to adjudicate all disputes that are related to the Olympics. That is not, in a way, a satisfactory reasoning, because it didn't really dive deep into Article 1 of the New York Convention. It was a very practical and good faith decision of this national court, saying if we can't allow CAS to have jurisdiction to adjudicate disputes linked to the Olympics, what happens? We're going to go to the courts wherever the Olympics are. That will be an incredible, complicated, kaleidoscopic chaos. And in a way, what has been said is, if you want to compete in the Olympics, these are simply the rules of engagement. So I wasn't too satisfied with that if I look at Article 1 and I look at the drafting history, because it has to be based on party autonomy and the parties' agreement, and parties have to voluntarily submit to it. So actually, from a, how should I, theoretical perspective, the decision wasn't sound. But the status quo today is that CAS decisions can and will be enforced under the New York Convention. Now, with investor state, this is really the billion-dollar question today, that will be discussed hopefully at some point by UNCITRAL. Is we have, in investor state, we have ICSID. So when the ICSID Convention applies, when bilateral investment treaties provide for ICSID, it all goes to ICSID. ICSID has its own enforcement mechanism. For the PCA and UNCITRAL, the New York Convention will apply. Now, this is provided for in these bilateral investment treaties. Now, again, this is one of these interesting situations where it is the states who have concluded that bilateral investment treaty, but it's then being invoked by investors. But again, these states conclude these treaties for their investors who are going to invest abroad, and to offer protection for foreign investors who come and invest in their territory. So the investors, in a sense, profit from that protection that is offered in these treaties, and the ISDS mechanism is a crucial part of it. So then it is ultimately the investors who submit a dispute to the PCA. So when it comes to the PCA and New York Convention enforcement, there isn't really a question. The question mark lies in the future, which is what if now states will say, we are concluding an instrument that no longer will create jurisdiction for an ICSID or a PCA, it will create jurisdiction for a court that we are going to establish. So that's much more like the International Court of Justice. The appointments will be done by the states. So it's not like you have a roster of arbitrators and the parties for each dispute can appoint an ad hoc panel. So the states are left out completely. And so then what is important is what is left of party autonomy. And if party autonomy is eliminated, one has to ask the question, would a decision fall under Article 1? Because do ICJ decisions, can they fall under the scope of the New York Convention? They're not being enforced under the New York Convention. But this is a very complicated conversation because the conversation has never taken place. Do ICJ decisions fall under the New York Convention? With the Iron Use Claims Tribunal, there are two decisions. Can those decisions be enforced under the New York Convention? And again, the reasoning was a practical one. Ultimately, those who go to the Iron Use Claims Tribunal submit their dispute to the Iron Use Claims Tribunal, and so therefore it's based on party autonomy. But it's really the states who have concluded the Algiers Accords, and there has been one person who contested that jurisdiction. So the magic word is really party autonomy. Is there party autonomy? Is that an element of the processes? And so if we were to have a world court that deals with all investor state disputes, I think party autonomy is gone. So my prediction is that the New York Convention cannot apply. So in short, for sports, the New York Convention applies. There is no controversy there, although if we really want to get theoretical and technical, there should be. And when it comes to more sovereign type of tribunals that are the result of agreements between states, and then an investor or an individual relies on it, it actually does become a question that we must address. So I hope that helps. I will actually tap into this throughout my lecture. So let me then go back to the reason. So I talked about the success, because everybody talks about the success of the New York Convention. So why then is the text of the New York Convention slightly pathological? So anybody who looks at the New York Convention will read the text and think a lot of this is complicated. A lot of this doesn't make sense. A lot of the drafting is ambiguous. Now, many treaties look like that. Why is that? It's because it's concluded between states. And the negotiation is often done by state representatives, often from the Ministry of Foreign Affairs. And it's not so much done by lawyers and arbitration and dispute resolution specialists. The politics come into play. And so therefore, the New York Convention, like many other treaties, is an agreement to disagree. And this is where I love to quote Fali Nariman, with whom we did the judicial dialogue, the New York Convention Roadshow in 2013, who talked about treaties, talked about the New York Convention, talked about that sovereign element, and said the New York or sovereigns who negotiate these treaties are like billiard balls. They collide often, but seldom do they go in the same direction. And if you just visualize that, you can imagine how treaties are negotiated. So what I then propose, even if we cannot replace the New York Convention, is to engage in that academic exercise of contemplating a new draft that can always be done in an academic setting among scholars and professors, because it enables us to better understand how judges should read the New York Convention when they apply it. And so how I call that, let's try to give them, the judges, a pair of reading glasses. So in other treaties, 4 other treaties, there is what is called the Harvard Draft, which was also written for a treaty. And that was really to just enable the interpreter to better understand the text. Now, we have guides, which I've shown so many times, which my students at JGLS are now working with. It's on the ICA website. This is actually a pair of reading glasses that we produced with the International Council of Commercial Arbitration, and it has checklists, and it has models, and it has roadmaps, and it makes it so judges now are quoting it. The Supreme Court of India has recently used it again. It's translated to 23 languages, and it has been very helpful. But it's absurd that a group of 5 people, which is what we were at the time, writes this little guide, and then it's being applied by judges around the globe. What should happen is that with state delegations, we sit together again, helped, assisted by experts to think about what is really wrong with the text in its application, and to create a manual or reading glasses, if you will, that is endorsed at the level of the UN, not written by 5 people. Now, why am I so cynical about the New York Convention? I will not go through the text because we simply don't have the time. I'm already, I think, half an hour into the lecture. So I'm just going to lift out some of the real areas where the shoe pinches. The first one is in writing. So Article 2 of the New York Convention is the article that provides for the recognition of the arbitration agreement. And it provides that judges must, in principle, recognize an arbitration agreement as binding. So what does this mean? It means that parties, in principle, have this fundamental right to access to courts. And the judges are the guardians of that fundamental right. Now, parties can decide we want to walk away from that right that we have because we prefer to submit our disputes to these specialist arbitrators. So business parties who engage with each other, shipping, oil, telecom, constructions, they might say for all sorts of reasons, if we have a dispute, we don't want to go to court, we want to go to ADR, maybe because in the courts that would have jurisdiction, there's a backlog, it will take too long, it's not confidential, or the judges are simply not specialized in that area. The other very important element is that in arbitration, you can tailor your rules. So parties will say, any disputes we will have, we want to go and have that adjudicated by an arbitral tribunal. So courts, when they are presented with an action under Article 2, must defer that dispute to these arbitrators. However, the New York Convention drafters have said the arbitration agreement must be in writing. And that is, how should I put this diplomatically? That's an outdated requirement. So in 1958, and one must understand that when you are negotiating, you're a professional in 1958, it's in the aftermath of World War II, that's your modern era. We now think in 2021, we're talking about artificial intelligence and blockchain and social media and God knows what have you. We're negotiating regional treaties, we're negotiating or rejoining important climate change treaties. The world is vastly different from 1958. But back then, that was the modern era. So what the drafters discussed is, today in the modern age, in 1958, the way business parties conclude their contracts, including that arbitral clause, is in writing. So those were the customs of modern international trade back then. More specified, the way it was done was a telegram or a telefax. So what the drafters were really trying to do is adapt it to the modern era. The problem is that 60 years later, telegrams and telefaxes no longer exist. And 60 years later, the pace of trade is so fast that business parties do not always put everything down on paper, especially in shipping. They start executing the deal. And at the time of executing the deal, there might not be an arbitration agreement in writing. And this has really been an important hurdle when it comes to the New York Convention. Now, UNCITRAL has tried to address that by saying modern ways of communication is no longer just telegrams or telefaxing. It is also electronic communication, but still that is a form of in writing. Whereas in today's modern day and age, there is also this concept of tacit acceptance. And many arbitration laws do not have that in writing requirement. Tacit acceptance is enough. This is really an article that just, it's no longer fit for modern trade, period. The second one is the enforcement of annulled awards, which in and of itself deserves a 2-hour lecture. This is another one that the drafters just could never have predicted, which is an award has been set aside in the country where that award was rendered. And that should have been the end of it. Instead, what happens is there are then courts of other countries that enforce that award. This is what I call the Yukos and the Pemex saga. Yukos is the award rendered against Russia. It's still unfolding as we speak. And Pemex has finally been settled. That was an award rendered against a Mexican state-owned entity. And this is where sovereign hits the hardest because sovereigns were involved. And then you see what happens, how courts react when an award is rendered against a sovereign. So international comedy slides in there. And there has been many creative theories have been developed by authors and by judges, but it has become in a way a toolbox of abuse. And it really, the moment is there that we have to recognize that reality, that for judges, it's almost impossible to address that challenge of the enforcement of annulled awards. And what happens is it becomes the box of chocolates. You don't know what you're going to get anymore. So there are 170 contracting states. The minute an award has been set aside, it can go anywhere. Now, the third one is what I call Pandora's box. So we've had the Telefax telegram drama. We've had the box of chocolates of Yukos and the Pemex saga, which I also call the Russian doll. And then we have the Pandora's box of Article 4. This is another one where the outcome was so different when one realizes what the drafters were trying to do and what ultimately happened. So what happened is the drafters wanted to improve enforcement as compared to the 1923-1927 Geneva Conventions and say, we want to make enforcement easier. Now, a way to do that in a more simple method was to abolish what is called the double exequatur. I cannot really get into that because that will take a lot of time. And to just say, if you want an arbitration, you want to enforce it in any other contracting state, you only need to submit the arbitration agreement and the award, and if necessary, a translation. The problem is that these documents must be certified and authenticated. And this is where we get into the what I call the W's, the where, the when, the what, and the who. Which agency, which consular official, which embassy should authenticate and certify? What needs to be certified? How does it need to be certified? And there are no answers, because this is, again, something that is felt in the domestic space. This is where the New York Convention is an anomaly, because it doesn't operate between states. It operates in the real national space where the winner in an arbitration, let's say a business person, has to then go to some consular agent trying to get all these documents ready. And we see in the practical outcome of the New York Convention that this is where things go wrong, where you try to submit this request for enforcement, you try to submit all these documents, and you just can't get it right. Now, judges so far have been very practical, but again, they have been practical by not really applying Article 4. And that's what we see. Their judges are not really applying Article 1 with the Court for Arbitration for Sports. Judges are not really applying Article 2 anymore with telegrams or hard copy documents. Judges are no longer really applying Article 5(1)(e), that annulled awards should just not be set aside. And judges are no longer really applying Article 4 because it's too complicated. So my question becomes, if judges are really being very practical and ignoring many of the instructions under the New York Convention, then why can't we rewrite it? Because now it's a bit of just sort of a guideline. The New York Convention is being used as a guideline. So forgive me for getting so passionate, but it's been a frustrating process when we're constantly confronted with the successful numbers. So what obviously happens, because we lawyers are tricky people, 60 years means a lot of case law, means a lot of practice rounds, means that lawyers have become savvy. Lawyers have created a toolbox with tricks. Lawyers have found a way to stop enforcement through the letter of the New York Convention. So even if an award was perfectly binding, and even if the New York Convention had this pro-enforcement attitude, not bias, but attitude, lawyers now have found a way to stop enforcement. That toolbox for abuse by savvy lawyers leaves us with the question, what do the judges do with this? Now, some judges, like Judge Jordan in Miami, said, when it comes to arbitration, we apply a hands-off approach. You parties did not want to go to us courts. You decided to go to arbitration. You decided to invoke an arbitration agreement. If you're not happy with the outcome afterwards, we're not here to grade papers. We are not here to grade papers. So that is maybe a solution, but then in 170 states, you who wants to rely on the New York Convention have to figure out how does it work. So while we are stuck with the New York Convention, if you will, I tend to advise look locally. So this international treaty that's a result of United Nations negotiations really only operates in the national space, used by national judges, and the only thing you can do is look locally. So this brings me to sort of the odd nature of the New York Convention, an international instrument that is felt in the national space. So that then brings me to those courts. So what do we have? We have the courts of what I call the courts of origin and the courts of enforcement. So an arbitration has taken place at the seat, the country of origin, where you have courts, and then it will be enforced wherever the assets are in the countries of enforcement with the courts of enforcement. Now, those two courts are equally important. There are some who have said there's the primary courts and the secondary courts. That is nowhere to be found in the New York Convention, is nowhere to be found in the drafting history. So we need to move away from that distinction of primary and secondary courts. There's the courts of origin and the courts of enforcement. Now, apart from the pitfalls that we then have seen in the New York Convention itself, there is the role that these two courts play. And so I want to step back for one moment to look at those courts of origin. So not the courts of enforcement. What do they do? And this is where I get into my Russian doll. They have the jurisdiction to look at the setting aside request. So what we will see in an arbitration, there is the successful party, and then there is the respondent. So if an arbitral tribunal has rendered an award in favor of the claimant, an award that allows that successful party, the winner, to collect under the award, the respondent, the losing party, will instruct lawyers to stop that enforcement. Now, one way of doing that is to request for the setting aside. And what we see is that today, most countries have adopted a setting aside regime that is based on the Amstel model law that mirrors Article 5 of the New York Convention. Now, why is this important? Let me just for 1 second go over the grounds. These setting aside grounds mirror the refusal for enforcement grounds. So the first one is the arbitration agreement. If there is no arbitration agreement, you can set aside and you cannot enforce. Now, that arbitration agreement, the assessment of the validity of that arbitration agreement, it's linked to the lex arbitri, so the arbitration law of the seat, the country of origin. It's linked to party autonomy. It's linked to Article 2, which is problematic. And it's linked to the parties' agreement, an agreement to have a dispute arbitrated in the country of origin. Second ground, due process. If the award violates the due process based on the lex arbitrio, this is Article 5.1b, the court of origin can set aside the award and a court of enforcement can stop the enforcement. Assessing that due process is based on the lex arbitri, the arbitration law of the seat. There we go again. Third setting aside ground that we often see that is also a refusal of enforcement ground is the mandate. If the mandate has been violated, an award can be set aside, an enforcement court can stop enforcement. Mandate is linked to party autonomy and the lex arbitri. Fourth ground, same thing. If the composition of the arbitral procedure or tribunal violates the parties' agreement, the court of origin can set it aside, court of enforcement can stop enforcement. Now, that question of was there a violation of composition is again based on the parties' agreement and linked to the lex arbitri and the seat. And then the last one of that ground 5.1 and setting aside grounds is the setting aside itself. So the moment a court of origin sets aside an award, all the courts of enforcement can say we cannot enforce anymore. So what do we see? That one, the grounds for refusal to enforce Article 5 are reflected in most national arbitration laws when it comes to developing grounds to set aside an award. They mirror each other. Even in the United States, there are many scholars and specialists who would say the New York Convention not only governs enforcement, it also governs setting aside. Why do I take my time to set this out? Because what we see with these grounds is that it's the court of origin that is versed in the law that needs to be assessed, the lex arbitri. It's the court of the seat. It's the court of the country where the action took place. The courts of enforcement don't know, so they are faced with whatever is submitted to them, whatever expert opinions are submitted to them. So my point has always been that the courts of origin are better suited to look at Article 5.1. To begin with, they're the ones who have to deal with the setting aside request. So what you get is what I call the Russian doll, which is the award is submitted to the setting aside procedure where you have the court of origin who is looking at all those grounds. That court is most equipped to do that. A setting aside might or might not follow. And then you get the other layer, which is the enforcement layer, which could happen anywhere where there are assets, where you have a court of enforcement not trained in the lex arbitri, who has to have a look at the exact same grounds. And this is where we get into the situation where I link back to theater, which is you have Act 1 of a theater play and Act 2. Act 1 is the extra arbitration, and Act 2, which is as long, lengthy, costly, etc., and unpredictable, which is setting aside an enforcement. So how then was this an efficient way of resolving disputes? It no longer is. So you can say, well, it's 60 years old and there are 170 states and there's thousands of decisions and it's amazing. Well, ask an investor and ask business parties if they think the same. There are now business parties who say we want to stay away from lawyers. Arbitration is not a strategy, and we end up in court anyway. So we go right back into history with the time turner, and we are with the courts again. And the one reason why arbitration took off, and the one reason why the New York Convention was so popular is it moved those disputes away from the courts. See, so I think I'm getting there now. I think I'm persuading many, like this is really not that great. So where are we then? What is setting aside? And what is Article 5 to stop enforcement? It focuses on the respondent's rights. So what is the whole rationale of drafters of the New York Convention and negotiators of national legislation? We have that fundamental right to access to courts. Parties move away from it. but we still have due process. So you have this dispute that is being adjudicated by private arbitrators, arbitrators that really anybody could be an arbitrator. So it's not really regulated. So it's really important that that adjudication was fair, that that winner is truly the winner. So it's important to have a system, a safety net, if you will, that still protects the respondent's rights. That is what a setting aside regime is all about. And that is what Article 5.1 is all about, the respondent's rights. My opinion, and I know many disagree, is that the court of origin is the best court to protect respondents' rights. Now, then we get into 5.2, which is what many call the unruly horse of public policy. This is where we get really into the billiard game of it collides and it never goes in the same direction. Now, why is public policy crucial and we could never get rid of it? It's because otherwise treaties will not be concluded. This is sovereignty. Countries are willing to enter into that space of the international rule of law, but they still need to protect the sovereign interest. This is just the reality of life. And so countries will not, state delegations will not sign on to something like the New York Convention if there are no public policy exceptions. This is simply something we cannot do away with. So 5.2 will always be there. No matter how you renegotiate a treaty, it will always be there. And so I'm keeping an eye on the time because we have to have time for questions and answers. And of course, that public policy question has to be left with the courts of enforcement because it's the public policy of the countries of enforcement. So that's where we are. The courts of origin are the experts on 5.1, and the courts of enforcement will always remain the guardians of public policy. And then we have all the other drama. Article 1 scope can no longer be applied, Article 2 in writing can no longer be applied, and Article 4, the Pandora's box of stamps and authentication is a nightmare. So this is where we are left with the New York Convention. I think I've torn it apart sufficiently. So what do I then want to do? I wanted to look at this replacement, and there are, in a way, two options. One is to have what I wrote in the India Journal, which is in a way you can have a convention that does away with setting aside. So you have a dual convention, which means that you will get a primary convention that is being applied by the courts of origin. So an arbitral award has been rendered. First port of call is the court of origin. So instead of doing setting aside and enforcement, any respondent that feels that his or her rights have been violated will invoke or will try to stop enforcement at the seat. So the winning party will try to get the title in the court of origin, and it's the losing party that can focus on Article 5.1 only. Now, let's say that court says, no, this was all valid, this award should be enforced, you get your first title. Then you can take that title anywhere where you find assets and where a convention applies. And then you go to what I call the secondary convention, which is effectively only 5.2. So you do have what I would then call a positive double exequatur. It means that if I want to just get a title from the court that actually knows, I can get it at the seat. So I just go there and say, okay, here's my award, here's my arbitration agreement. I don't have to translate anything because you're the court of the seat. That court says, okay, this looks good, prima facie, et cetera, et cetera. And it's the respondent who can say, wait a second, lex arbitri, valid arbitration agreement, due process, et cetera, et cetera, et cetera. Maybe the court then says, well, actually, yes, one of the refusal grounds for Article 5.1 applies. I'm stopping the enforcement right here. End of story. If the court says, no, Article 5.1 does not apply, the successful party can then take that first exequatur and go anywhere else. And the only thing that can then stop enforcement is public policy. That's it. So you, in a way, you reduce all those layers of the Russian doll. The other option is that you just keep setting asides. And so what happens is, if ever there would be a reason for the award to be set aside. That will happen in the country of origin. That is then the end of the story. Enforcement is simply not possible. Or that setting aside procedure is unsuccessful, in which case the successful party gets a stamp, goes anywhere, and the only thing that stops it then is public policy. Now, I know there are many, many technical questions. This is more sort of the broad concept of a new way of enforcing. So that is my concept, that you have a dual convention, that you have, in a way, two systems, but it respects the role of the courts of origin and the courts of enforcement. Now, I knew when I wrote this that it was going to be all too easy to attack this concept. Now, why do I know this? It's because my mentor, Adriaan van den Berg, did the same exercise in 2008. He had to speak at the Dublin conference, the ICCA conference, about was the 50-year anniversary of the New York Convention. And he thought, what can I talk about at this point in time? So he said, let's do a hypothetical exercise. If we would be writing the New York Convention today, what would it look like? So it was really just an academic exercise. That was called the Dublin draft. But then because we developed it further in Miami, we redubbed it the Miami draft. The backlash was incredible, still to this day. Now, again, the argument is 170 states, the number of positive enforcements, et cetera, et cetera. How would it be possible to get 170 states to sign on to a new treaty? The new treaty will also have to be negotiated. The new treaty will also be an agreement to disagree. The new treaty will have to have compatibility clauses, clauses for retroactive application, more favorable right clauses. What is the question on setting aside regimes? How do you negotiate that? The national legislators have to abolish that. In other words, the technical questions, there are thousands of them. But here is my question today. If it's so difficult to replace one treaty, how come that we are now with UNCITRAL and the Working Group 3, and states are enthusiastic about the concept of replacing thousands of bilateral investment treaties when it comes to their ISDS clauses, and that states are excited about the concept that ICSID would no longer have jurisdiction? And there too, many, many technical questions were raised. Questions were raised about how does this work? How does that instrument work? How are you going to implement all of this? How would the New York Convention apply? How will these adjudicators be appointed? Who is going to appoint it? How do you have some? There are many more technical questions related to that debate than technical questions that would arise when it comes to replacement of the New York Convention. Yet that does not deter the stakeholders. Second, when it comes to numbers, let's just go back to the numbers again. The Mauritius Convention has been signed also under the leadership of UNCITRAL. This is the Convention on Transparency, because there was so much criticism on the lack of transparency. I checked yesterday, 9 contracting states. The Singapore Convention, oh, the new competitor, mediation. How do we enforce the mediation decisions? This is going to be the future. This is so important. It's been so successful. 7 contracting states. However, those 2 treaties have been hailed as a success. So that's a bit of a contradiction, isn't it? The New York Convention can never be replaced because it has 170 states, but then again, the ISDS system can be overhauled completely. And then there are 2 treaties that are arguably so successful, and they haven't even reached the number of 10. Second, what do numbers really mean? So this is where I want to link back to my article that I wrote, because some of it is still relevant. If you look at the significant number of states that are a party to the New York Convention, well, wait a second. What does that mean? And I'm just going to read what I already wrote years ago. Yes, but these states have omitted to take the most basic formal steps necessary to ensure that its commands are integrated into national law. The result is that the treaty, the New York Convention, is a dead letter in their courts. The truth is also that courts in other states have interpreted the convention in an arbitrary or chauvinistic fashion. without the least regard for consistency or reciprocity with practice elsewhere, thus frustrating the purpose of the New York Convention. So sometimes age is just a number, and numbers are just numbers, and they're empty numbers. And it's important to understand that we need to stop obsessing over one, the numbers, and two, the technical. So, and this is where I want to conclude, because I think I need to leave time for questions. I think I have made my points as to why the New York Convention isn't really as great as it looks like. Second, the numbers aren't really the numbers that we think that they are. 3, yes, I'm aware of the technical questions. 4, I'm aware of the political sovereign element. But then this exercise, even if it doesn't lead to a new treaty, it could lead to the following. We can think about optionality, which is now also something that's being discussed at Working Group 3, which means that we create an instrument based on optionality, where some states can say, we want to opt into this new treaty that provides for sort of this primary, secondary mechanism. You can have your compatibility clauses so that it's up to the states to say, you know what, I want to allow parties through Article 7 of the New York Convention, the more favorable right, to use this new mechanism, optionality. The second is we can use this exercise to create soft law, which can be used under Article 31 of the Vienna Convention for the interpretation of treaties. The third is we can copy the concept of this Harvard draft. And the fourth is we can create a task force that looks into all those technical questions that arise under the Vienna Convention of the Law of Treaties: retroactive application, compatibility, more favorable, how do states sign on, how do they become bond, how do they denounce all treaties, etc. We have to be stubborn. Perhaps 2008, when Albert Jan Vandenberg raised the concept of the Miami draft, maybe it was simply too early. It was a year after UNCITRAL issued its recommendations for the New York Convention. International arbitration did not yet enter its PR crisis that it finds itself in today. And geopolitically, we are in an entirely different world. Geopolitically, but also at the level of treaty negotiations at UNCITRAL. ISDS reforms, Singapore Convention, Mauritius Convention, NAFTA being replaced with USMCA. It's a different world out there. And so there might be momentum to look into this exercise. If we are not doing that, I will predict that the writing is on the wall with users of international arbitration, whether it's International Trade Business Party or investors, will say arbitration is no longer a strategy. Alternative dispute resolution, at least arbitration, is no longer efficient. It's no longer cheaper. We're going to opt for mediation or commercial diplomacy. So this is my new bold Dutch proposal. The first one was in 1958 by Piet Sanders, and now we are in 2021, and we've got another crazy Dutch person who wants to do something absurd. I'm going to stop here because I think we have about half an hour left, I think. And if there are questions, I'm happy to try to address them.
Thank you so much. Thank you, Prof. I have a lot of questions, but we'll let the audience ask first because I profusely highlight the book. So I have a lot of questions, but we'll let the audience ask. So please do raise your hands, or you can put your questions in the chat if you're unable to mute yourself, but please use this opportunity. We have almost a half an hour slot to just discuss your questions. Yes, please. Yes, Ankit.
Well, first of all, thank you, Professor. I'll use this opportunity to further what we were discussing in class as well. I'll base this on the premise of what Kissinger once said, that states really don't have friends, all they have is interests. What I proposed in class was that enforcement and recognition seems to be a rather superfluous exercise of differentiation. To this end, if the states are are coming to the table to negotiate a treaty, they in some sense do have some sort of recognition of not only the treaty making process, but what it will yield in the end. To in some sense you do vitiate the discussion on recognition and not really enforcement, but there is one hurdle cleared, and you remove one layer of the matryoshka with that exercise. So that's just what I'm trying to grapple with and find some sort of understanding on. And the other point which I would just like to highlight, I'm not sure if this is a question or a comment, it's just that if there is a procedural law which needs to be created and substantive law which needs to be laid down, you can't have a blanket understanding of it in terms of who should be accepting it, or the court, or where the court of origin is, or where the court of enforcement is, because that's an exercise that the states have to be involved in by themselves. And that the space and the clarification which needs to be provided is a domestic exercise by the virtue of the states being party to the disputes in themselves. So in that sense, I really don't understand. Perhaps I'm confused over here on the discussion of the four W's, and is it really required that it needs to be dealt with? So those are just the two comments which I've been trying to get my head around over the past week since I've started attending your classes and other lectures. Thank you.
Thank you. That's many different, very important issues raised. So I think one, if you will, oversight of the New York Convention. So when you talk about recognition and enforcement, the title says recognition and enforcement, and every time there's a reference to enforcement, it says recognition and enforcement. This is something the drafters did, where effectively it's about recognizing the arbitration agreement and enforcing the award. To me, it's terminology that is not all of it has to be repeated in every sentence. And it feels like the drafters were really thinking about how can we make this as clear as possible, but then the end result is that it's ambiguous. Now, one problem with the New York Convention is it doesn't have a preamble. It doesn't have a list of definitions, whereas most treaties do. And it was the Pakistani delegate who said, well, I don't think we should do that. We should just leave that to all the countries themselves. So again, you have that an element of sovereignty that actually backfired. Now, the New York Convention really relates to procedure. So one important thing, both with setting aside regimes and enforcement regimes, is that courts are not allowed to look at the merits. So the dispute has been adjudicated, like let's say the contract breach. The only thing the courts can look at was there due process violations. Did the arbitrators do something they were not supposed to do? Did they go beyond their mandate, et cetera? So it's really procedure, but indeed, it is a state level dialogue. This is the issue. This is that sovereign billiard ball, because Article 3 refers to the rules of the procedure where the country of enforcement. Article 5.2, arbitrability based on the laws of the country of enforcement. Public policy based on the laws of country of enforcement. There's constantly a reference to a national law. There are so many multiple different references to different national laws. That becomes a bit of a maze to find your way. And this sort of the synergy with those setting aside regimes. So this is very, very much one at the level of a national legislator. And second, also, what are the national laws already in place? So Article 3 has all surveys and books and God knows what have you in and of itself, because parties need to understand what are the rules of procedure in those 170 contracting states. So that's jurisdiction, that's what do you need to submit, where do you need to submit, which district, blah, 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 blah. That is very hard for foreign parties to navigate. Due process is very domestic, but also burden of proof and evidence is not regulated in the New York Convention. And this is why it's such an odd treaty. It's all really in the hands of each state, the national legislator, and the laws that are already in place. And so that's why I feel we need to try to think through how you could have an improvement that recognizes that reality. Now, one way to do that is to engage in dialogue. So what we did after we made this book, I thought, well, then we're just sending it over to judges, but that's not very helpful. So I then came with this proposal of doing New York Convention roadshows to just travel to countries and meet with judges, which we've now been doing for 10 years. And we then changed it into a dialogue because roadshow, I think it was even with Fali Nairman that he said it's better to call it a dialogue. That has been incredibly helpful. But one thing that I would now like to do is write a policy guide for legislators and the executive, and then do roadshows or dialogues with the policymakers, the stakeholders, and legislators to understand how they would react to all of this, because it's in their hands, as you say. So that's something I would want to do, even if it's virtual. And then when it comes to state entities, and this is what I tend to say, the minute it's about an enforcement or a setting aside for that matter, where the losing party is a respondent is a state entity, you have to have 1,000 red flags that are being raised, because courts will act differently. We will, well, this is in class, sorry for all those others who are listening, but in class we will be discussing UCOS and PEMEX. And the reason why those are really the sagas, the juicy cases where things are a box of chocolate, is because of that element of international comedy vis-a-vis that state entity. This is where we get into the murky waters. Now the W's is Article 4. And this is the way the rules and civil servants sadly operate. So, and again, the drafters were acting in good faith. They said, if a party comes with an award and an arbitration agreement to prove that that award needs enforcement, we judges need to be able to ascertain, is this the real deal? Is this not some sort of copy that they wrote that's not even, written by these arbitrators? So the draft said, well, it should be certified. Somebody with the competence should certify that this is legitimate. And then they even talked about in New York in 1958 about, well, who should that be? Should that be a consular agent of the country where the award is rendered? Should that be a civil servant or this or that of the country where enforcement is sought? And then again, the draft said, well, we'll just leave it. We'll just leave it to the states. And as a result, nobody knows. Because anybody who will try to get a visa for anything, or let's say you're trying to find out how you can travel in times of COVID, you don't even know who to call. And that's what Article 4 is. That's why I call it Pandora's box and the W's. Where do you get your award certified? Who has to do it? How much? And here's the practical problem. The practical problem is it takes a lot of time and it's costly. So I hope that answered your questions. But of course, we will have time to dive into this in the class, about which I'm very excited. Are there any other questions?
Yes, please raise your hands if you have a question. I don't think there's anybody else raising hand. So because we have time, I'll ask my question. Ankit, you're on mute,
Well, there's just one which is coming, so perhaps I'll hold mine and let
Yeah.
this one be
There's
asked.
one on the chat, yes.
Should I read
Um,
it out?
it's about mediation. It says, when you spoke, Prof, I'm reading out from the chat. When you spoke about mediation individually, I too had a point that communication is really a need of the hour. And when I say communication, I too talk about peace and trust in order to save sovereignty and trust of all. So as to provide justice to injustices. I'm sorry, wait, I just can't see the rest of the chat. So one sec, sorry. Yeah, it says to provide justice to injustices happened with so many, and mediation really can help us build a good home or a better society to live in. The question which I have is how should we see 1958 model and the 2021 model that you propose as a model of change? And what are the factors we really need to look upon in order to bridge the gap and not allow anybody to interfere in this process? Because I assume it is not that easy to achieve.
Good advocacy and good diplomacy. And what I mean is and as I also try to explain to my students, I think that from a technical point of view, having studied everything, years of following how the New York Convention operates, we have technically very good, solid arguments, and we have enough competence to create a model that might be a huge improvement. There are the naysayers, and then there is the issue where, and I think that's what this question is about, even if the ICC or UNCITRAL or whichever body would say, let's have a task force. Even Jindal could have a task force to say, because the first task force started with ICC, to say we are going to think about what this model would look like. In that processes, you can have sovereign interests, all sorts of interests, just self-interest, agendas, God knows what have you, that obstruct the methodology, that obstruct progress, right? This is what we see also at Working Group 3. It's all at the end of the day, no matter what you're trying to do, no matter what you're trying to accomplish, it's a matter of really excellent advocacy and what we call at my firm stakeholder engagement. So you need to form coalitions, you need to find stakeholders, decision makers, governments, policymakers, institutions to wanting to be part of this. And then it becomes a matter of excellent diplomacy. And what I always say, those agents for change are often the disruptors, but you need that disruptive change. Somebody needs to start the debate. And so what I'm hoping is that at some point, some organization, or even a part of a ministry, or even a university will say, this has to happen, this dialogue, let's set up this task force. And that's what happened in 1951 with the ICC. And that's what happened now in, I think it was around 2016 with the ISDS reforms. It was one or two people who said, let's take this to UNCITRAL. And here we are years later with all these state delegations showing up. So it's good advocacy, stakeholder engagement and diplomacy that hopefully will lead to disruptive change that will lead to positive change.
Right, thank you. Ankit, do you have a follow-up?
Well, I'll just pick up from where Professor left, disruptive change. To this understanding, what the European project is seems quite inviting. Now, we've discussed the origins of it, or what at least I assume the origins of it to be. But I somehow sense skepticism from Professor, and I would like to hear more about the skepticism of the European project as a separate court altogether, and what sort of challenges will that provide to the convention? Because, as I would see it, it rather reinforces the convention.
So we're talking about the ISDS reforms, correct?
Yes.
Oh, well, I am as skeptical as I could be as a specialist of law, because this European project, as if one will, it totally eliminates any party autonomy on the side of investors. It's that simple. It is that simple. This is not arbitration. This is not dispute resolution for international trade. This is not based on party autonomy. This is not based on due process. This is not based on fairness. This is sovereignty at its best. This is states want to sign on to an agreement, a concept that allows them to have something with no strings attached, that allows them to not ever be held accountable. Investors will have no say whatsoever in who their adjudicators are going to be. So they might as well go back to domestic courts, which is something investors don't want to do. And so I will predict that if this happens, the cost of political risk insurance will go up significantly. So investment will become more expensive. And if the European bloc will simply say, well, that's not true, well, judgment day is coming, and those investors will take a stance. And the powerful investors will say, we're not going to this court. So they will use the power that they can yield and say, we're negotiating contracts. And we're negotiating contract-based arbitration. This is a court that seems to be tailored after the International Court of Justice or WTO, but wait a second, the International Court of Justice is state to state. So why I'm skeptical about the European project is, it is to put investors at a great disadvantage. And if anybody thinks that the investors don't know this, think again, because they do. And so this is the whole premise of international arbitration, investor-state dispute settlement, is to create an equal level playing field. Because one party is an investor and the other party is a state. So to go to courts of that state, you don't have your day in court. You don't have due process. That's the whole reason why the PCA exists. That's the whole reason why ICSID exists. And what we're doing now, we're going back to something that is exactly like a domestic court. It's just that it's a world court. And this is what I write about in this article that I wrote, that I write about in my book, that Fali has mentioned, and Martin Hunter and Pete Saunders and all the old titans from back in the days. Because actually in the 90s, there was a debate to have a world court for the enforcement of awards. And then the living legends of arbitration said no, because it's going to be a sovereign creature. And business parties don't want to go there. And so we do well to remember that this exercise has taken place before, and that those who really know what they're talking about said, it can't, because sovereignty is the stopper. And again, I'm getting very passionate about this topic because it is so important for me that we think about fairness and due process, and that we remind ourselves that we're talking about international trade. Go ahead.
Yeah, I'm sorry. You all can continue. I'll just be back.
Oh, no, it's fine. I'm done. I'm done.
So the net result would be that arbitration as a modus operandi would suffer greatly, and there will be a loss of trust and faith in the system, which perhaps has worked efficiently.
And so those really paying the price is obviously not the big corporations, it's SME, so small and medium business enterprises, because they don't have the negotiation leverage to negotiate contract-based arbitration. And so they will have, the only thing they will then have is this court. So the SME, that sector, they are effectively deprived of proper, fair, neutral adjudication. And that's why I'm as a scholar, and I was vocal about this years ago when all of this started, because we think it through and think about what will this legal, theoretical, technical debate lead to in real life. And we're not talking about big mining and big oil and big this and big telecom. We're not talking about the Vodafone cases. We're talking about the small businesses that would want to, let's say, manufacture clothes and deliver them, ship them to somewhere else, who now no longer have a resort. I see something in the chat, or?
No, that was just me. I think we can let the others. Is there anyone who has more questions? Anybody? All right, Prof, I have a question. So you've been pointing out the several concerns with the New York Convention. I was also wondering what your opinion is on just the reservations part of it, especially because of how we in India are seeing our enforcement mechanism working out vis-a-vis the ISDS awards that haven't been enforced in India and are trying to get enforced elsewhere. That India has expressed the reciprocity reservation, and therefore we only actually enforce awards from 41 of the 162 countries that have ratified the convention. And more importantly, the commercial reservation, which is where the entire debate on the ISDS awards being enforceable under the New York Convention comes in. So while I do know that there is a little bit in the article, as well as you do talk about it in the book, I thought maybe you could talk a little bit about the whole commercial reservation part being problematic.
In India, it's problematic. So the reciprocity reservation, almost at the time, it was obviously very important. Now with 170 states, and those are mostly the important trading nations, it's a bit of a moot point. But the commercial reservation, again, it seemed to make it's a lot of common sense, right, that was being used by drafters in 1958. It just seemed logical. You know, it should only, the New York Convention is about international trade. It should only be for commercial things. Now, a lot of states are a party to the New York Convention, to the ICSID Convention when it comes to investor-state disputes, but India is not. So for investors who have claims against India, there is the PCA. one of them. And so the enforcement mechanism then automatically becomes the New York Convention. India has the commercial reservation. So the question now is, and it's being answered differently, by the way, we did a webinar on that with Jindal where it was, there's no agreement, let me put it that way. So the question is, this is an arbitral award where the enforcement is requested under the New York Convention, but it's an award that is linked to the ISDS settlement mechanism. So it's an investor state award. Would that be excluded by the commercial reservation? And UNCITRAL has addressed that. UNCITRAL has defined what is commercial, and they give a long list, and I have that in my book. And one of the items in that list is investment. So if one were to go by the guidelines of UNCITRAL, one can say investment is commercial, and therefore the commercial reservation does not exclude the enforcement of ISDS awards in India. That's also my view. But again, we will have to divert to the judges as how do they interpret that. And this is again where we have the box of chocolates.
Right. And I thought I'll ask a follow-up considering that entire discussion on the World Investment Court happened. That, for example, Brazil, Korea, they only have the mechanism of the SSDS ombudsman in their VITs. And this is something that India actually moved towards and adopted the Brazil model in the India-Brazil VIT. Now, the India-Brazil VIT is not in force yet, but the text is out and both the countries have signed it, but they haven't brought it into force. And it's a very interesting VIT because it kind of takes up on the Brazil model for India and departs from the India VIT by now mandating an SSDS style mechanism, which is like the Korea weird version of the Brazilian understanding of SSDS. And that kind of is even more complicated because those SSDS awards will never get enforced under the New York Convention mechanism. So what's your opinion on that? Just the whole idea of BIT-led SSDS outside of the world system.
So Brazil, interesting enough, I was on the phone with them yesterday. I'm vice president of the Global Institute for Peace Studies with the University of Sao Paulo, and I work a lot in Brazil and with Brazilian stakeholders. And of course, when there are side debates that relate to the ISDS reforms, many bring up Brazil, and they say, Brazil doesn't have that traditional investor state type of protection, and look how well they're doing. We had as a general counsel of Viacom, who gave a keynote lecture at the University of Miami about how she navigates the landscape in Latin America. And she talked about Brazil and how she negotiates with the Brazilian stakeholders when she invests in Brazil. Good experiences. I think the reaction to that is that Brazil stands alone in that region. Brazil is, when it comes to trade, in a different position as opposed to the other countries. So they also have the luxury to create their own infrastructure, and they will still attract foreign investment. And so that's what you, in terms of governance and as a policymaker, have to think about. What can you afford in terms of how you as a country can attract foreign direct investment, and where you stand in the geopolitical landscape when it comes to international trade. Brazil has the luxury to just decide on its own settlement mechanisms. Brazil has many leading dispute resolution institutions like COMCCBC, but also with the University of Sao Paulo, there is now the Center for Conflict Resolution, where we use a lot of mediation. So not ombudsman, but they have their own system in place that works really, really well. And so my point would be, is India in the exact same position regionally? And I cannot answer that question. I think you would be better positioned to answer that question, although I have a feeling of where it would go. So this is very dangerous to, in a way, tailor after Brazil when they're really in a very unusual position, as is the European Union. right?
And if I may, I think the Brazilian adoption of that model was based on a very endemic Korean model. It was for their local investors.
Yeah,
That was transplanted into the Brazilian regime for international investment, but
yeah,
it's also still very peculiarly Brazilian. And
exactly.
therefore, at least as an academic, I am very, very for we go at the cost of sounding dramatic, fearful of the consequences of something like this in a BIT. That also has India as a party.
And if there is no enforcement mechanism, because the New York Convention, you can only stretch the New York Convention so far. If there's no enforcement mechanism, then what's the value? If you can't enforce it across the globe, what's it worth? It's a piece of paper.
Exactly, yes. Correct. Yeah. Thank you so much. Are there more questions? Please do ask your questions. I see some people who should ideally have questions, but people aren't. There is one in the chat, Professor. Investment comes under the ambit of commercial definitions, but international investment law aims to protect another aspect of investment, which is political risk. So my question is how could courts differentiate business risk and political risk?
Well, the question is which courts?
Enforcing courts, when understanding the meaning of commercial under the New York Convention, if investment state arbitration is commercial, then how is commercial taking account of political risk when that's a subject matter in an investment agreement?
Well, I mean, is it a business? When we talk about political risk insurance, here's the thing: foreign direct investment, international trade, businesses. You have two types of. It's the same type of risk. It's a financial risk that is linked to doing business with states. So we call that in our firm, we call that political risk insurance. It's an insurance because when you deal with governments, it's a different, it's a risk you take. You don't know when there's dispute, how are you going to recover, right? So this is about, for example, licenses that you need from the government and that are being withdrawn. It's about you're being expropriated. Now, what is important to understand is that is a risk that is there, whether you are a business party where you have a multi-party agreement with business parties and state-owned entities and some branch of the government, or whether you're a foreign investor that has like a direct deal or investment in a country and then something happens, right? An expropriation or license being withdrawn, the risk is financial. And so there are a couple of things you can do. You can conclude these insurances because there's political risk, or an investor will say, or a business party will say, it's okay, because if there's an issue, we can adjudicate it in front of a neutral forum. So I would want to steer away from making the distinction between business risk and political risk. As an investor, you have multiple contracts on your table. You have multiple investments on your table as a business company. So let's say Viacom, for example. And whenever you have your investments, your factories, your shipments, your deliveries across the globe, there's at some point always some government entity involved, right? You need to get your licenses, you need to get the land, you need whatever it is. And there are various ways of putting that into some sort of legal infrastructure. And sometimes that leads to a contract-based type of arbitration, where then you would call it, I guess, a business risk. Or there is, we have all the contracts in place, and then when the time comes, we will, for example, rely on a bilateral investment treaty. But the risk is related to doing business in other countries and dealing with sovereigns or dealing with entities, getting licenses. So in a way, my argument will be, as is clearly the reasoning of Procedural, is it is commercial. It's commercial. And so I would not want to dive into kind of bifurcating it between business or political, because it is the same. It's business entities, partners, companies who have cross-border business. And so in every, like whatever you will, let's say you have a very small company where you, let's say you have design items that come from India that you want to supply, you want to set up a worldwide shipping system, right? You're a business entity, you're not a foreign investor, but you will have to deal with some local rules elsewhere. Now you can just seal any protection through all sorts of contracts, or you can say, when the time comes, I want to rely on some treaty protection. But it is what we call political risk insurance, but it's related to business. So that's why I would argue it's, however you call it, whatever nomenclature you use, it's commercial.
Right. Thank you so much. I think we can stop here. It's past 12:30 India time. So thank you so much. And thank you everyone for showing up and being interactive. Thank you, Prof. I'll see you next week.
See you next week. Bye-bye.
Yeah. Bye. Thank you, everyone. Have a good weekend. Stay safe. Ajay ji, you can stop recording and stop the live stream. Thank you.
Okay.